So this is a really actually important piece here. So this is in the report of, I think it is 1832. So the 1832 committee report of Parliament on public petitions. This is where Sir Robert Peel was on the committee. This is like 2 years before Parliament burned down. They writ this. So they give a full list of, according to this, unless they've missed anything out, which supposedly they haven't, but they were meant to have, apparently they went through all the journals, all the parliamentary journals, and put together all the resolutions for public petitions, right? And it is from the Journal of the 19th of April, 1620, from which they attribute this piece here. Now, remember that there wasn't really a modern proper form of a public petitions committee until 2000 and after 2010. I think they had a clerk of public petitions, but they didn't have a proper committee. They'd sort of decided to scrap it, I think, in the 1970s. I think that 1972-1973 report is talking about winding it up and finishing it. So all through the 20th century, mainly, there was a very low number of petitions. But the modern staff at Parliament that have sort of seemed to start putting out a lot of material, mainly starting around since the time Tony Blair did the number 10 Downing Street e-petitions, right? They use this, and they say, basically, they use this, and they kind of extrapolate it and frame it, that they say that they mean that, or they think this means that Parliament can reject any petition, right? It's got the right to reject it. It's not fit to be received. Now, so this is the proper wording of it, which is a little bit different to what Parliament are trying to make out it means, okay? Now, this was 1620. Now, the House of Lords had triers of petitions, but the House of Lords are getting in different petitions because they're dealing with a lot of judicial appeals and judicial matters, privileges of servants and all that type of thing, right, which is in their standing orders to receive them. So their triers of petitions, I think, are made of judges, members of the House of Lords, and so forth, right? And I've actually, there's a couple of books published on that, which are quite relatively new, published probably around just before I got interested in it. And I found those two books are quite expensive though, but I'm going to buy them. And I think one of those two talks about these triers of petitions. So I think that person will have done quite a lot of research into it. This does mention it and tell you about it, right? But the House of Commons, I think, dealt with them differently because the public petitions were maybe ever wanting to get the law made or changed. But a main part of it is grievances and maladministration of government. So, but there are the things that the current modern e-petitions are not letting us do. They won't want to publish them. They don't want to have them on there. But that's one of the main functions of petitioning. And John Pym says parliaments are those for where we come and resolve our grievances. So it's not just about getting laws made and changed. The current e-petitioners committee want everything to be looking good, make the government look good, always neat and prim, and it's all about getting laws made and changed, and let's not talk about anything else, and let's, petitions are from individuals, real living people with a story and misfortune or events happening, or even finding things the government are doing wrong, or maladministration, or evil ministers being removed, and government are trying to kind of wanting to get rid of all that and filter it away, or not, at least not letting you easily tell people about it and getting support to make them act on it, right? It's not just about getting legislation made or changed. Now, this talks about legislation, right? But when it means legislation and things that the government can and can't do, it's not just getting laws made and changed. But anyway, so 1620. What can we say about 1620 before we read this? So Charles I had not made the Tumultuous Petitioning Act, right? Which, oh no, what was it? Charles II even? Charles II, sorry. Charles II had not even made the Tumultuous Petitioning Act 1661 after the Civil War in the Restoration. So you didn't have to go to a court or before a jury to attach your privileges to a large number of people. There's a book published 1628 which gives an example of a writ of privilege, and it says it's there for servants and followers of parliamentary causes. Now, I'm quite sure that the petition itself, a petition to the king, was recognised as a original writ, a matter of record, through the observation of the Due Process of Law Act 1368 or 1386, whichever, right? And that was actually for petitions. And then you've got the Statute of Westminster II, when you can petition the king if there's any justices are doing anything wrong in the courts, right? So we know that if you had a petition or were doing petitioning, the petition itself is the writ, but if you're having problems getting it enforced, you could get a writ of privilege from your MPs, right? And there wasn't any limit of number of people that could do it, but obviously Charles II said that it was causing mischiefs because a lot people were also using the authority of Parliament to arrest people and maybe take them to Parliament and things like that on kind of like vexatious charges, or like William Prynne. William Prynne got arrested and they didn't say what they were charging him with, and he got held in different castles for 3 years, right? And William Prynne was saying that, what about his rights? And really William Prynne, was doing a lot of writing about rights and things like that. So kind of a little bit like William Prynne got sort of waylaid for 3 years by malpractice, although he survived, but he did get his ears chopped off as well. But apparently he claimed that they didn't actually have a proper cause for it or whatever. So sort of things similar to that, right? And then William Prynne saying that, there's lots of abuses of the right to petition. But this is before, way before 1688, when it got put into constitutional law, right? So we don't have the Tumultuous Petitioning Act at this point, but we know that people are petitioning the king when there's parliaments called. And if there aren't parliaments called, they might be petitioning the king and his council, right? And they are using writs of privilege, and they're engaging in matters of the country, right? And remember, a lot more people were getting warrants then, and engaging in law enforcement. Public engagement in law enforcement was through the sheriff's office, completely different to now. Now we leave everything to the police, except ringing 999, or maybe we've got a mobile phone footage or whatever. But then we were participating in law enforcement, so using rights like to act physically or get evidence or whatever was a lot more hands-on in those days. So it was just a more natural and involved legal process in all things. So to do it to Parliament and have an existing process by which you might be doing mesny processes and doing things in order to take a case to Parliament, and also you've got all your civil arrests and civil cases, it wasn't anything out of the ordinary other than that it was under a different jurisdiction to Parliament and not through the local law, right? So we've got to take into account, the observation of due process of law. Now, the thing is that a petition to the King and Council or to Parliament is, when you draft it and write it, it's like if you go to court and a Crown prosecutor prosecutes someone, right? It's something, it's not nothing, right? Or if you go and get a civil claim. So it is, how often do Crown prosecutors get their cases disregarded or tossed off to the side. I don't know, but the court never says that their investigation's invalid. It would be interesting to know if a police officer kicked down a door, arrested someone, and the police wanted to charge them. Then they submitted it to the court, and the court said, "Oh no, we're not going to hear that case." I'd like to know what happens to the police if he gets prosecuted for kicking the door down, or if they just leave it and forget about it and say, "Oh, we're not going to continue it any further," right? That would be an interesting question. But anyway, so what does this actually say? Taking into account that when you're petitioning, it is a writ original. When you go on the Scottish Court of Sessions website, they've got petitions, and when you fill it in, it says like insert arms in England. You're filling a proper legal document in, right? So it's never just like nothing. It's never just scrap of paper, right? Not if you're seriously taking it seriously yourself, right? Now here it says that so the diverse petitions. Oh, sorry, right. The diverse petitions rejected by the committee, right? And so endorsed, yet not thought fit to redeliver them without direction of the House, moveth, when any rejected by the committee, they may be redelivered to the parties by the committee, right? The appointing of the chair at the committee was referred to the discretion of the committee. Right, so, now what does this mean then? Well, this is the thing, right? Now, how petitions are fit to be received or not meant something different then to what it means now. It's a lot to do with handwriting, eligibility, people's ability to read and write in English, if they're literate people or not, and if signatures are eligible, handwriting, signatures, seals, things like that, if it's fit to be received. The paper might be on a type handkerchief, right, or it might be wet, right? That is a large part of it, which is now they're trying to make out, now because we don't have any of those problems at all, that you can type it in on a computer, the letters are quite clear, the information is clear, it's not going to get damaged, burned, wet, damp, a hole in it, tatty paper, a handkerchief, or scrawled on a bit of cloth, or God knows what, if it's covered in mud, right? Those are likely to be 50 to 90% of the problems that they had, whether it's fit to be received, right? And if it was actually something that they could or could not ask for, why would they be bothering to make the effort, right? Now, yes, there is the language and etiquette and so forth and being insulting, but I would have thought that would have been a much smaller part of it. So, when we get to the modern time, and when we don't have any of those 90% of the problems, right? Now, when everyone's literate, when it's electronic and, it cannot be tatty or broken or worn or without spellings or questions about the signatures, there's a very small amount of problems. But what this government have done now is they've zoomed in on those 10%, 10-20% of problems, right, of which the rest of the problems are now vanished and gone. And now what they're doing is excessively, heavily over-scrutinising, blocking and rejecting things which you can petition Parliament on. You've always been able to petition to Parliament on, and the literacy is like compared to what it used to be, like, next level. There's no such thing as really not knowing what someone means unless you're retarded, right? And they're making new excuses up from completely fully illiterate pieces and things that you actually Parliament really can do, and for a completely totally ridiculous and false reason of their new standards, rejecting probably more petitions than got rejected in the olden days when they turned up covered in mud, tatty holes in them, or not even any spelling properly on them, or you couldn't even read them right. And some of the main, even the Lord Mayor of London says that petitioning is to point out malpractices in government, right? Remove evil ministers, personal grievances, and asking for laws to be made and changed. Now, they're not allowing any of that, even though it's the main thing. They're only entertaining petitions which are really trying to be extremely oversensibly, with little humanity left in it, right? Like it's made by an AI summary or something, asking for some policy to be changed or act of law to be altered or whatever, or something to be done about this tax or that tax or tampon tax, right? And what they're actually doing is they're disallowing nearly 90% of what the whole point of it exists for, right? Because they don't want to actually have to acknowledge it, right, officially, or people to support. They don't want people to support it. They don't want people to know about it, and they don't want to acknowledge it, right? Right? And this is their new standards, and they're using the excuse that they can judge whether it is fit to receive. Now, what I found out is that the petitions committee itself, right, when they can call for papers and documents and summon people, it's not meant to be to investigate the petition or anything alleged in the petition or the matter contained in it. It's actually only meant to be in order to understand the petition, understand the subject, and, make sense of it. They're the ones who have got to learn it, learn the petition, learn what it's asking for, go find out, right? And then they're meant to be allowed to, they can write a summary of it, which will be printed to Parliament or to the MPs, right? And they are allowed to reword it and rephrase it when it's printed, summarise it. But that does not destroy the original petition, the original evidence, the original claim, which is received and recorded, right? Now, what they're doing at the moment to us is they're rejecting our original writ, they're rejecting our original wording, they're rejecting our original claim, right? When they could quite easily receive it and then they could put up their summary of it, right? Which is what ends up getting put in print. And then that wouldn't be making us change our original prayer, change our claim. What they're actually doing at the moment is trying to stop you from claiming a certain thing or submitting certain evidence, but it's always received because it's a legal claim original, right? That's separate from them printing it and publishing it in order that the MPs can have a better idea of what it's about or a shorter idea of what it's about. And then, if it gets investigated, then obviously they'll still have the original thing that you submitted, how you wanted to submit it, right? Now, this is the thing. It says here that diverse petitions rejected by the committee. Now, let's get this very clear, right? If you read like Gilbert Campion's book on petitions, or I think it is, there's another book by another MP, not Erskine May. It's not Erskine May because he's a clerk. There's another book. The guy slipped my mind at the moment. It's a blue book. He's also included quite a lot of the... I can tell you who it is when I just look, if I look at my phone, right? But I can tell you it's a blue book on parliamentary practice by an MP, right? And he said that when the petitions are received by Parliament, right, the clerk can advise an MP on it, on whether it should or shouldn't be presented, but the clerk only advises on it, right? The clerk is not a judge or the speaker. The clerk only advises the MP on it, right? So he might advise against it, but the MP could still possibly present it or, put it in the bag or the table. Now, the speaker might then object, or some other members might object to it. So the clerk's only advising on it, professional advice, remember. The clerk is not a judge. So the clerk's got some say in it, some sway in it, but they're not a judge, remember. Now, when it gets presented in the House, it gets put in the bag or whatever, and at a later stage, they can do motions and certain things on them and read them out, right? But it's received, though. So even if the clerk advises against it, an MP can still support it, and it's still received, right? Now, at that point, an MP can ask, fill a form in and get a petition sent up to the gallery, and they can ask the newspapers to print it or mention it, right? And that is completely separate from it being given to the committee, who assess it and then summarise it and then order it to be printed in the proceedings, right? That's separate. So it can be publicised and mentioned when it's received without the committee intervening, right? Let's get that clear. Now, when they are sent to the committee, this is talking about if the committee itself reject it and don't want to it to be published in the votes and proceedings, or to pass it on to another committee to deal with, like the Privileges Committee or the Forfeiture Committee or the Committee on Housing and Benefits or whatever, because they can be passed to other committees to deal with, right? But they're not meant to be passed to government departments, because government departments aren't elected by the people. They're not members of Parliament, and they're not ministers, and they're not the Speaker. They're not elected, and they don't have the judicial power of the High Court of Parliament, right? Because this is a writ original by the observation of due process of law, right? This is like the courts, okay? You got to understand that, right? Now, all petitions that are of a grievance of privilege, like if you've been doing other petitions and you get arrested illegally, which are of a judicial nature, right? They're not going to go to the petitions committee, right? So they're not going to get rejected by the petitions committee, right? And you can present those yourself, and you don't even need an MP to present it at the Bar of Parliament or to sign it, because it's a legal matter, it's a judicial matter. So you've got a legal right to go to court, basically, and you don't have to have a solicitor represent you. You can represent yourself. So you're meant to be able to get like a remedy from the Speaker of Parliament by presenting it at the bar, or from the House from votes of MPs, without it necessarily being an MP who presents it, right? So that's not going to go to the Petitions Committee for assessment, right, and then reject it at all anyway, right? So an MP can get it printed if he really wants to by the newspapers, but we have got the right to put it in the newspapers ourselves anyway, because how did we get the signatures in the first place? And this is before the 1661 Tumultuous Petitioning Act, where you had to get consent to get more than 20 signatures. This is before then, so you didn't have to get consent, right? Nothing stops you putting it in the newspapers and sharing it, right? It's privileged. You're trying to collect signatures. You're trying to tell people about it. And then you hand it in with the signatures, right? But it says diverse petitions rejected by the committee. So that's when it does go to the committee, and then they don't even though a member supported it and presented it, and it might have even got read out to the House. The committee have decided that they don't want it to be in the votes and proceedings, or to do a summary or publish it, right? Now, the thing is, after 1661, right, if you'd gone to a court, okay, if you'd gone to a court and got a jury to say, yeah, you can do this petition to Parliament and get more than 20 signatures, or 3 judges had, surely it's going to be, they must have checked, they must have decided that it is fit, right, for Parliament to receive it, because there was a judicial decision in a court, either by 3 justices or an official jury. So if after it had been ordered by a jury or with a jury by 3 justices, right, and they said that this petition is perfectly fine to do to Parliament and we support it and consent it, wouldn't it be ridiculous if, the Clerk of Parliament's didn't support it, or if the MP supported it and then he sent it to the committee and then the committee sent it back, right, after 3 judges have said that this is something Parliament can do, right? So it's unlikely after 1661, if you got over 20 signatures, it's unlikely. This committee is really going to have to not like it if you've got 3 justices who supported it, right? So that needs to be mentioned as well, right, and taken into account. But it says that diverse petitions rejected by the committee and so endorsed. Now that word endorsed, yet thought not fit to redeliver. Why endorsed? What it was? So it's been. So let's say an MP presents it. Let's say that he supports it, but then the committee rejects it, right? So why is it endorsed? Well, it's endorsed because it is a writ original through the due process of law, right? And it might have been to a court. And then a jury in front of 3 justices might have said that this is perfectly okay, right? So it can be endorsed. It is a legal claim. Now, what this is saying is, though, that an MP might have supported it and read it out, right? And an MP might have even asked for it to be published, but then the committee might say that they don't want it to be put in the votes and proceedings of Parliament, which is separate from the newspaper, right? So they send it, what they're saying, they're sending it back to the MP and back to the chamber assembled in Parliament, right? Now that means, and it says here that for redelivery without direction of the House. So now the modern petitions committee are basically saying that if they reject it, they're effectively sending it back to you, right? Sending it back to the person, like Parliament's returning it to sender, return to sender, right? And that it hasn't even been acknowledged or received. But I think this means otherwise. I think this means that, yes, it's endorsed because it got signed by the public, right? If it's got signed by 20 people, it's endorsed by the electors, right? It's endorsed by the electors, and it might have been endorsed by an MP, right? Or even a court, 3 justices, right? Now, but the committee might not want to put it in votes and proceedings or pass it on to another committee. So it's saying that they can only resend. It goes back to the chamber then, because even though the committee's rejected it, the chamber might still be able to vote on it themselves, or the MP, right, or the speaker. It's just that petitions committee is not going to put it in the votes and proceedings or refer it to a committee. Does not mean that anything cannot be done from it, and that's what this means. But then the House can have it sent back to the sender or returned, right? But it's still endorsed. It says even though it's still endorsed, so because it might have been endorsed by a court. Now, if it's been endorsed by a court, it's a proper legal claim, right? It is a writ original by writ. Insert arms in England, insert the royal arms in England, right? I've been to a court in England. I've had 3 justices hit a hammer down on a pimmel, right, in a court. If that ain't a legal claim, I don't know what is, right? So this validates all of your investigation, all of your signatures, everything you did in order to get the petition in front of the committee in Parliament. And this is why in some of these committee reports, it says, you know, like Mr. In the 1944 report, I think it might be Mr. Tinker, John Tinker MP, or Gilbert Campion, I can't remember, but they said, you know, this is not child's play. This is not child's play, okay? It's not child's play. It's like the Crown Prosecution Service, right? They've taken over, right? Everything they do is serious. Anything we do is, you know, chuck it in the bin, it's a handkerchief, right? But yet that's not the case. It's not the case. So this has actually been heavily misconstrued at the moment, basically to mean that you send a petition in and then they're not interested in it and then they send it back, right? It's not fit to receive.